A very warm thank you to the organizers of this conference for having organized such a fascinating program and for inviting me. I'm really sorry that I cannot be there with you in person. Unfortunately, the beginning of an academic year also comes with teaching load for all colleagues, and that also applies to me. That's why I have to record this intervention. I hope that it will nevertheless be interesting and engaging, and if any of you has any comment or question, I will be very happy to hear from you via email, for example. I will not abuse of slides because I know it can be distracting during a recorded presentation. I will only use them when strictly necessary. The topic is blockchain-based dispute resolution mechanism, and I'll try in under 20 minutes to give you a little overview of what I see as the state of affairs and my personal opinion on the topic. I will start with the first part, where I will basically draw a very brief history of the relationship between blockchain technologies on the one hand and dispute resolution on the other hand. And it is a short but not non-negligible history by now. And then against this background, I will ask myself the question, what are these dispute resolution mechanisms? Are they a form of arbitration? And of course, this question is not only interesting from a theoretical point of view, but also practically very relevant, because arbitration comes with its own recognition and enforcement mechanisms. And therefore, it potentially opens the door for coercive enforcement of a dispute resolution outcome in the way that other mechanisms of alternative dispute resolution do not. So the question is also practically relevant. And then in the third part of the presentation, I will ask myself a complementary question. That is to say, to the extent that this is not arbitration, should we find ways to make the outcomes of these dispute resolution mechanisms nevertheless enforceable in another way through channels other than, for example, the 1958 New York Convention. I will now for a few minutes share my slides so that you can just follow me in my, so to speak, historical overview of the topic. Now, I will not describe in detail what blockchain technologies are. I think that is something that has been already repeatedly done throughout the different days of the conference, but I would like to point out a sentence in this very famous, infamous, if you will, paper, the white paper of Bitcoin, the first ever distributed ledger technology to have gained such massive attention and use in the world. Now, the paper is pseudonymous, as you probably know, so this Satoshi Nakamoto is by now an almost legendary figure. Nobody really knows who the authors of this white paper are. But what is interesting for us to notice is that the original intention of the authors of this white paper was to create a peer-to-peer electronic cash system. So the initial purpose of the creators of Bitcoin was actually to create a new means of payment. For which purposes? Well, if you read the white paper, it comes across quite clearly for e-commerce. So to pay for goods and services to be bought online. And if we look at the history of Bitcoin since, we know that this is not what happened. Bitcoin has gained enormous momentum, but not really as a widespread means of payment, more like as an investment vehicle, for example. Nevertheless, in the original intention of the drafters, that was the idea. And there wouldn't be any third-party centralized intermediary between seller and buyer. And that came, of course, with a number of immediate questions. One of the most obvious questions, especially in the field of consumer e-commerce, is who would protect buyers against sellers' fraud? It's a typical e-commerce problem, not specific to blockchain technologies in any way. And there's a fairly mysterious sentence in the white paper that I would like to highlight. According to the authors, in this highlighted part, routine escrow mechanisms could easily be implemented to protect buyers. So in other words, according to the authors, buyers could protect themselves without relying on a trusted third party by simply creating an escrow mechanism where the price of the transaction would be stored so that it couldn't be stolen, so to speak, by the sellers without the delivery of goods. How does this work in practice? Well, we know this because this is not just a theoretical construction, it's something that has been implemented in practice, first on the Bitcoin blockchain, and then on many other blockchains that have come after that. There are many ways to create an escrow transaction. The most popular one, at least for a long time, has been the so-called multi-signature transaction. So I will briefly explain what that means, because I think it's important to get a basic understanding of the technical aspect of things before asking ourselves, is this arbitration? Is this not arbitration? So let's suppose that there are two parties, buyer and seller, that want to, for example, buy or sell C equivalents. Buyer has a certain amount of cryptocurrency in its wallet, and seller has the goods to deliver. How does a multi-signature transaction protect the buyer in this context? Well, a multi-signature transaction operates like a lock with two keyholes. So in this case, the price, the cryptocurrency, wouldn't be transferred directly from the wallet of the buyer to the wallet of the seller. To the contrary, the buyer would transfer the price into a special account, a special wallet called a multi-signature wallet that can only be opened if two keys that are passwords essentially are used. So once the coins, the price of a sales contract are stored in this multi-signature address, it can only be unlocked if the parties jointly agree, because both parties are given one key each. And one key by itself is not sufficient to unlock this type of wallet. Two keys must be jointly used. So if the transaction runs smoothly, the seller will deliver the goods to buyer, and the parties will use the key jointly to open up the multi-signature wallet and unlock the funds that will be finally transferred to the wallet of the seller. If there is a problem, for example, if seller refuses to deliver the goods, so there's a problem of failure to perform the contract on the part of seller, there's a dispute, so the parties do not jointly use their keys, but there is a third party, an adjudicator, also provided with a third key. The third key is once again not sufficient to deliver the funds to anybody, but the adjudicator can hear from the two parties, decide which of the parties is right or wrong, and then use their key together with the key of the winning party to unlock the funds in favor of either the buyer or the seller. So this escrow mechanism, this multi-signature transaction, however you want to call it, is not really a procedure. It is a technical infrastructure for enforcement, right? For self-enforcement, which is interesting because even if I'm using the word enforcement, I'm not really involving in any way state authority. In a way, it's an erosion of the state's monopoly over the use of force. These are private arrangements that allow the parties to devise a dispute resolution mechanism that enforces itself to a certain extent, to a limited extent. Of course, the remedies are very limited, very rudimentary, essentially concerning the amount of cryptocurrency or other digital assets that have been stored in that particular multi-signature wallet. So what is it? Is it arbitration? Is it not arbitration? It's not a question that can be answered in general terms. It depends, of course. It depends on what type of procedure the third-party adjudicator provides to the parties. In theory, this type of technical infrastructure can be used to empower an arbitrator to self-enforce an award, and the arbitrator, tribunal or sole arbitrator, might conduct a procedure that looks exactly like any other type of arbitration procedure under the law of the seat, whatever that might be. But in practice, we have seen that this type of possibility, technical possibility for self-enforcement, has triggered the proliferation of a number of dispute resolution mechanisms that do not resemble a traditional arbitration. Many of them are based on game theoretical incentives, so that a wide audience of token holders are able to judge a case, so to speak, or to vote on what the correct outcome of a case might be. And they stand to gain or lose tokens depending on whether they choose the majoritarian solution or not. I will not say much more on that, because on this panel there are people that are much more knowledgeable about the ins and outs of applying game theory to dispute resolution, especially for small value disputes. But I will say those procedures are different from a traditional arbitration. They're, of course, less judicialized. They typically do not provide for long deadlines and an oral hearing with parties represented by legally qualified counsel. They're a different type of procedural animal, so to speak. And so when it comes to the question, is it arbitration or not? Of course, it depends on the features of the procedure. What I can say in a few minutes right now is that the self-qualification of the procedure is essentially irrelevant. So it doesn't matter whether it's called arbitration or not. And we have multiple examples of this. One of the most prominent ones is emergency arbitration. It's called emergency arbitration, but if you look at the case law comparatively, there are legal systems where judges tend to agree that it is a form of arbitration, but other legal systems where they say, for me, this is not arbitration, even though it is called emergency arbitration or emergency arbitrator procedure, or however it is called under the applicable rules chosen by the parties. What is relevant instead? Well, there's a number of factors that, depending on the applicable law, might come into play. Just to mention some, under some national arbitration statutes, it is relevant whether there is a predetermined number of arbitrators. If you look at the Armstrong model law, that's clearly the case. If you read jointly Articles 2 and 10 of the Armstrong model law, there must be a predetermined number of arbitrators. And that is already a deal breaker for many of these game theoretical means of dispute resolution, because any token holder, or at least an unpredictable multitude of them, can cast votes on a dispute. And that's kind of incompatible with the idea of typically a sole arbitrator or a panel of 3 arbitrators. There is, of course, the problem of independence and impartiality. For example, Article 12 of the Armstrong model law on international commercial arbitration. Well, arbitrators in theory should have no economic incentive to decide the case one way or another. They shouldn't stand to gain or lose money depending on who wins or loses the case. And here, in many of these systems of game theory-based dispute resolution, jurors do stand to earn or lose tokens. So they do have an incentive. Actually, that's why the system works, right? Because those incentives should discourage bad faith behavior, and practice shows that they do, in fact. There's also, I would say, as far as decision-making is concerned, a fundamental difference. Not only in terms of the substantive law and the substantive standards that are applied, it's a very different animal, but also because on an arbitral tribunal, in theory, under most national laws, all arbitrators have equal powers. And that means also voting powers in case of disagreement, with the presiding arbitrator sometimes having certain powers to break deadlocks. But in general, every arbitrator has the same weight on the tribunal. And that is not really the case in many of these systems where, depending on the entitlements in terms of tokens, the voting power might be higher or lower. But that's also an interesting difference. Again, I'm not really judging whether this is bad or good. It's just a matter of descriptively outlining some differences that might prevent us from qualifying a certain procedure as arbitration. There's nothing wrong with it. There's many procedures that are not arbitration, and we accept them already for decades, and they work very well. One of the most typical examples is ICANN dispute resolution for domain. It's not arbitration. Everybody uses it. It works very well. Another requirements that might be relevant under national law and also under the New York Convention, as long as we don't think that there is a universal notion of arbitration in the convention, which I don't think there is, to be honest. Article 31 of the Ancestral Model Law, for example, tells us that an award must be made in writing and signed. And that's not typically how these new forms of game theoretical dispute resolution are based. They're not based on something that looks like an arbitration award. They're based on a mechanism of self-enforcement. So I would say many systems of law would conclude that this is not really arbitration, and therefore the route towards international enforceability, for example, is not the one of the 1958 New York Convention. That brings me to the final step of my very short presentation, that is to say, should we somehow find a different route towards enforceability for those procedures that do not contain sufficient procedural guarantees and features to qualify as a form of arbitration? Well, practice has already partially answered this question in a famous case coming from Mexico that I think other panelists will discuss. There is a technique that is essentially borrowed from the award by consent or award on agreed terms. Essentially, two parties might agree to use a certain game theoretical dispute resolution mechanism, but they could also enter into an arbitration agreement, appointing a sole arbitrator with a very specific mandate, not to adjudicate the dispute, but to essentially look at whatever outcome has been generated by the online procedure and copy-paste that outcome into an award so that it also counts as an arbitration award, essentially opening the doors for off-chain enforcement. So as to combine both best of both worlds, so to speak. It is not the same as a settlement agreement being recorded into an arbitration award for the mere fact that in the case of a settlement agreement, the parties agree on the content of the agreement to be recorded into an award. And here, the parties essentially agree to a settlement contract whose contents are not determined yet and will only in the future be determined by this wisdom of the crowd. Is this possible? Is it not possible? It depends on the applicable law to the contract, of course. In some legal systems, clearly it is possible to do so. But I would say that does not really guarantee necessarily international enforceability. Because even though a certain legal system, Mexico, for example, might allow the parties to record the outcome of that, for example, Pietro procedure into an arbitration award, which becomes then an enforceable title in Mexico. Other legal systems might disagree as to whether that is an arbitration award at all. And even if they think it is an arbitration award, they might think that, for example, there are public policy concerns, procedural public policy concerns, because of how different the procedure has been. And there's a good reason why there's a numerous clauses in most legal systems of enforceable titles, because that gives you access to state force, essentially, to public coercion. So the question is, if there are some forms of dispute resolution which currently might not lead to international enforceability, is that a problem? Do we need a new international treaty convention providing for the enforceability of those outcomes, like the Singapore Convention is trying to do for settlement agreements? I would say, to be honest, in my opinion, absolutely not. There are very good reasons why certain dispute resolution outcomes are not enforceable titles. And in my opinion, there are good reasons why the parties might want to choose a dispute resolution procedure that does not lead to res judicata, that does not prevent them from then ceasing course later on. ICANN dispute resolution has worked very well for a very long time without realizing any type of compression, a limitation of the parties' right to cease course and review the outcome in litigation if they want, which rarely happens, but it might happen. So from the point of view of an institution like the Hague Conference, and more in general for any of us who are interested in the harmonization of cross-border litigation law, so to speak, or dispute resolution law. Is there anything to do? In my opinion, there is a gap. And the gap is not really about the guaranteeing of enforceability, but about the creation of a non-institutional set of arbitration rules, much like the UNSTRO arbitration rules have done for international commercial arbitration, and then they have been applied very successfully to investment cases. A set of arbitration rules that will enable any interested party and any arbitrator, without necessarily involving an arbitration institution, to conduct a procedure that will be partially self-enforcing on the blockchain because of this infrastructure that I very briefly outlined, and partially enforceable off-chain because it also counts as an arbitration award. But that, of course, requires ticking certain very important procedural boxes and guarantees. I think a set of uniform rules could enormously help the industry to tick both boxes in a way that respect very important due process fundamental guarantees. I'm very curious to know what you think about this topic, and I would be very grateful if you could send me an email with your feedback or comments or questions. My email, as I hope you can see here, is pietro.ortolani@ru.nl. Many thanks for your attention, and once again, my apologies for not being there in person, and a very good conference to everybody.